This is Rushi Patel, Associate General Counsel for the Georgia Municipal Association. GMA is proud to present Part 2 of this webinar, Weapons in Georgia's Cities, Navigating Georgia's Laws on Firearms, Weapons, and Local Governments. Part 2 relates to government buildings. Before we begin, let me read this disclaimer. This presentation should not be used to substitute for timely advice from the city attorney. Municipal officials should rely on their city attorney to apply the law and judicial interpretations to the specific fact situations they face. In some instances, relevant statutes have been summarized to address key points in a concise manner. The opinions expressed in this publication should not be used or taken as legal advice. The remainder of this part of the presentation will discuss one part of the law that affects government buildings. The changes to this part of the law take effect on July 1st, 2014 and revolve around one key paragraph in the new Georgia law, OCGA 16-11-127E1. You will notice at the bottom of many of these slides there are site references, and this section is no different. A license holder shall be authorized to carry a weapon in a government building when the government building is open for business and where ingress into such building is not restricted or screened by security personnel. A license holder who enters or attempts to enter a government building carrying a weapon where ingress is restricted or screened by security personnel shall be guilty of a misdemeanor if at least one member of such security personnel is certified as a peace officer pursuant to Chapter 8 of Title 35. Provided, however, that a license holder who immediately exits such building or immediately leaves such location upon notification of his or her failure to clear security due to the carrying of a weapon shall not be guilty of violating this subsection or paragraph 1 of subsection B of this code section. A person who is not a license holder and who attempts to enter a government building carrying a weapon shall be guilty of a misdemeanor. The remainder of this part, again, will discuss this paragraph and paragraphs relating to this paragraph. So the first question that comes up when discussing government buildings is, what is a government building? Well, this is a defined term in 16-11-127A2, and a government building is a building where a government entity is housed, a building where a government entity meets in its official capacity, and if it's not a publicly owned building, then it's only a government building while the government entity is meeting in that building. Or a government building is any portion of a building that is not publicly owned that is occupied by the government entity. For instance, if the city rents the 5th floor of a building that's a private building, only the 5th floor would constitute a government building. Now, a government entity is also a defined term, and that means an office, agency, authority, department, commission, board, body, division, instrumentality, or institution of the state or any county, municipal corporation, consolidated government, or local board of education within this state. So the definition of government entity is a broad definition, while the definition of government building is very specific to certain places. Another key question for this part of the law is, what exactly is a weapon? Well, weapon is also a defined term, and it is defined as any knife with a blade greater than 5 inches and any firearm which has a barrel equal to or lesser than 12 inches. Firearms that discharge a single shot of 0.46 centimeters or less in diameter are not considered weapons for this part. Effectively, what this means is that a weapon is a handgun or a large knife. So weapons means handgun or knife. Then the follow-up question to that is, what about rifles, shotguns, and other long guns? Long gun is also a defined term, and it means a firearm with a barrel length at least 18 inches and an overall length at least 26 inches that is designed to be fired from the shoulder. These weapons are prohibited from all government buildings. I'm going to repeat that. Long guns, rifles, shotguns are prohibited from all government buildings, whether that government building is screened by security personnel or not. So long guns, rifles, and shotguns are prohibited from a government building no matter what. A common question is, can we just post a sign? And the answer is no. A city cannot simply just post a sign prohibiting weapons from a government building just to prohibit the firearms from that building. In order to have an effective firearm prohibition, weapon prohibition from that government building, there actually has to be security personnel posted at the entrances to that door, screening and restricting access to the building. The posting of a sign is not allowed under the new law. A common question posed by cities is the city mandated to post security? And the answer to that question is also no. If the city is forced by budgetary constraints, or if the city simply wishes to allow weapons into the government building, then the law makes no requirements that the city post security at the government building in order to allow weapons into such building. So simply put, if the city cannot afford it, or if the city simply wishes to allow weapons into the government building, then there doesn't need to be security at the door. But if the city does wish to prohibit weapons into a government building, then security does need to be posted. Does that security have to be a post-certified police officer? And the answer to this question is also no. If a city chooses to prohibit firearms and weapons from a government building, the only requirement is that ingress into the building be restricted or screened by security personnel. However, if the city is restricting ingress into the building and wishes to charge a license holder with a misdemeanor, then at least one member of the security personnel must be a certified police officer. So basically what we're saying here is that the security at the government building controlling and screening, restricting access to that building does not necessarily have to be a post-certified police officer. However, if the city wishes to be able to charge a license holder with a misdemeanor in the event that a license holder attempts to enter a government building with security, then at least one member of that security personnel team must be a certified police officer. However, again, on top of that, before a certified police officer can charge a license holder with a misdemeanor, the license holder must first be given the opportunity to voluntarily leave the government building or leave that location. The law first requires the license holder to be able to voluntarily leave the building. Then a certified peace officer would be able to charge them with a misdemeanor if the license holder refuses to leave that location. A very common question that we have received is, does our city need to have or buy metal detectors? And the answer again is no. The law only requires that the city prohibiting firearms and weapons restrict or screen ingress into the building with security personnel. There only needs to be security personnel restricting and screening ingress into that building. How the city does that can be determined by the city, but there's no requirement that the city go out and buy equipment or buy metal detectors if they're trying to restrict or screen access to that building. The general question then comes up, what does restrict or screen ingress mean? And the law does not define such a phrase, and the city attorney should be consulted. However, there is no requirement for pat-downs, metal detectors, or sworn officers. The only requirement is that security personnel restrict or screen ingress if the city is choosing to prohibit weapons in that government building. Can we restrict firearms only during certain times? If a city wishes to allow weapons into the city building while the building is open for business, say for instance from 9 to 5, but wishes to prohibit weapons at a city council meeting starting at 6:30, then the city can have security present for the times of the council meeting to accomplish this goal. Effectively, what this would mean would be that from 9 to 5, weapons would be allowed in the building. But at 6:30, if the city posts security controlling ingress into that building and is restricting and screening such ingress with security personnel, then weapons could be prohibited from the building during that council meeting or zoning meeting. Who must pass through security for a weapons ban? The law is silent as to who must pass through security and which entrances must be covered. It's almost certain that all persons passing through public entrances must pass through security for an effective weapons ban. As for other entrances, cities should consult their city attorney. What about government-owned buildings that do not fit within the definition of government building, which are leased to private parties? If a building or other city property, such as an arena or fairgrounds, does not house a government department or meetings of the government, basically what we're saying is if that public building does not house a government entity or meetings of a government entity, but that public building is owned by the city, then persons carrying weapons or long guns cannot be excluded or ejected from such building, even when such property is being leased to a private party. And you'll see the code sections there cited to 1611-127C and 1611-173B. Okay, so the city does not have security. Who's allowed to bring in weapons? Only license holders. Only license holders can bring weapons into the building. This means a person holding a valid weapons carry license. It's a defined term. How are people without valid weapons carry licenses treated in government buildings? A person who is not a license holder and who attempts to enter a government building carrying a weapon shall be guilty of a misdemeanor. This applies whether the government building has security controlling access or not. Effectively, what this means is if a person does not have a license, they cannot enter a government building at any time, whether they're security or not. If they do, they have committed a misdemeanor. We don't have security. How do we know who is a license holder? City personnel may ask to see a person's weapons carry license, but that person cannot be detained. They cannot be detained, which means they cannot be stopped. They cannot be stopped from moving freely unless there is a reasonable suspicion another crime is being committed or about to be committed. A visitor is under no obligation to reply to city personnel, including police, if asked to show his or her license. Again, a person cannot be detained under the new law just to see their weapons carry license. There has to be a reasonable suspicion that another crime is being committed. So the common question after that slide is, we cannot detain to check their license even in a government building, and that's correct. The only time a person can be detained for a license check, whether in a government building or not, so this means out on the street, out in a city park, anywhere, the only time a person can be detained for a license check is if there is a reasonable suspicion that a crime has been committed or is about to be committed. A common question after all of those is, doesn't that treat people who do not have licenses as if they are license holders while they are in government buildings? And their answer is yes. Unless there is a reasonable suspicion that the person is committing or about to commit a crime, the city cannot detain someone just to see their license. So that means whether the person is a license holder or not a license holder, the city cannot detain them just to see a license unless there's a reasonable suspicion a crime is being committed. A common question is, could the city create a list of license holders in the state? And the answer is no. The new law makes it a violation of state law for any person or entity, including city governments, officials, and employees, including police, to create or maintain a multi-jurisdictional database of information regarding persons issued weapons carry licenses. What this means is that the city cannot gather data on license holders from neighboring jurisdictions in order to have a database of license holders available. If there are any questions, the city employees, city personnel should consult their city attorney for any legal advice on how to apply Georgia law. Part 2 of this presentation has been presented by Rishi Patel, Associate General Counsel of the Georgia Municipal Association, and my email is rpatel@gmanet.com.